Distinguished guests, ladies and gentlemen, friends of the organization, good evening and welcome. The HSF was founded in 1993 to honor the life of Helen Suzman. One of the founding principles of our mandate is the promotion of the rule of law. And we have throughout the years advocated for judicial reform and for reform of the Judicial Services Commission. Today's talk, therefore, is critically important for us and timely. I wish to remind ourselves of Judge Ismail Mohammed in the Constitutional Court, which I think is very apt today as it was then. He said, "Unlike Parliament or the executive, the court does not have the power of the purse, or the army, or the police to execute its will. The superior courts and the Constitutional Court do not have a single soldier. They would be impotent to protect the Constitution if the agencies of the state, which control the mighty physical and financial resources of the state, refuse to command these resources to enforce the orders of court. The courts then could be reduced to paper tigers, with a ferocious capacity to roar and to snarl, but no teeth to bite and no sinews to execute what they then would become a sterile scholarship. Its ultimate power must, therefore, rest on the esteem in which the judiciary is held within the psyche and the soul of a nation. That esteem must substantially depend on its independence and its integrity. The court held then, and it's important still now, that the strength of judicial oversight depends in no small measure on ensuring that our judicial appointment processes attract and result in the selection of the best possible candidates to serve as judges. To maintain a judiciary that enjoys public confidence and fulfills its constitutional mandate, appointments must be made in accordance with Section 174 of the Constitution. The Foundation is honored that former Chief Justice Zondo will be delivering this year's address and will be engaging some of the burning issues around judicial appointments in South Africa, including the appointment processes of acting judges. The adoption of new guidelines for the selection and appointment of judges in 2023 under the leadership of then Chief Justice Zondo has been welcomed. But questions remain. Are organizations like HSF and other civil society organizations correct in asking questions like, is the composition of the JSC appropriate for its purpose? Questions have also been raised about what happens with acting judges. How should they be appointed? What criteria are we going to use? Should they be the same for permanent judges? Is there, therefore, a need to reconsider the model we have used thus far? I welcome you all to what promises to be a thought-provoking evening in honor of our patron, Helen Suzman. To further introduce our topic, I introduce to you board member Phila Zulu.
Good evening, ladies and gentlemen. I'm terribly sorry that you now have to endure me. I was hijacked by my colleagues to basically, who asked me to give just a brief statement on why we chose tonight's topic and why this particular speaker. I'll leave the actual introduction of the speaker to those charged with that duty. But when I was considering what to say about the topic of why we need to re-examine the judicial appointment model in South Africa, I found myself repeatedly stumbling on the traditional reasons around why judicial independence is such a cornerstone of our democracy, any democracy for that matter. And I could list them, and you've all heard them before: to uphold the rule of law, to maintain the separation of powers, to keep power accountable, and I could go on. But I thought I should spare you the constitutional law lecture and perhaps try something a little more creative, at least as creative as a lawyer can try to be. So I turned to the internet and sought some more creative ways of tackling the request, and was able to piece together the following analogy, which I cannot attribute to any one person, but I most certainly cannot attribute to myself. So here we go. Imagine justice as a lamp glowing in the middle of a dark room. Around it stand three giants: the legislature, the executive, and the people, each holding their own torches of power, passion, and opinion. The lamp in the center belongs to the judiciary. It burns not because it is loud or strong, but because it is steady. Its flame must never flicker in the winds of politics, fear, or favoritism. It shines only with the oil of truth, fairness, and the rule of law. If one of the giants leans too closely, trying to shade it, control it, or use it to light their own cause, the lamp's glow weakens. And when that happens, shadows fall all across society. The innocent can be punished, the guilty can go free, and power can go unchecked. That is why the independence of the judiciary is so important. It keeps the lamp burning with a pure flame, guiding the giants, not bowing to them. It ensures that when justice speaks, it speaks not in the language of rulers or crowds, but in the calm, unwavering voice of the law. Because when the lamp of justice is truly independent, everyone, from the most powerful leader to the poorest citizen, stands equal in its light. So, ladies and gentlemen, that's why we have this speaker and this topic. Thank you.
Good evening, ladies and gentlemen. Yes, I must say, Chief Justice, my view is that the responsiveness of an audience depends on the melanin content of it. Good evening, ladies and gentlemen. I hope you gasped. But the non-melanin people are learning. How are you, ladies and gentlemen? Are you well? I'm delighted to be here. And really, it's a wonderful occasion. And I'm also very pleased to be able to introduce Ray Zondo. But I first want to tell you two fun facts about him. The one is that his son is an international cricketer and has cricketed for South Africa. And the second is that he has a beautiful and charming and imposing wife called Ste, who's not here tonight. But please tell her that I mentioned her, Ray. So we know the outline of Ray's career. Ray Mnyamazeli Mlungisi Zondo was born in May 1960. He completed his schooling at St. Mary's Secondary in Ikopo, and he then entered the University of Zululand studying to be a lawyer. There's a telling and poignant footnote to Ray's studies, and it's well documented in the media. There was a shopkeeper near his home in rural KwaZulu-Natal, Mr. Books, who regularly served the family. And when Ray went to university, he extended credit to the whole family for the years that Ray was at university, an extraordinary gesture. And of course, there's a racial edge to it, because Mr. Books was Indian, and Ray was a young man at that stage without credentials or distinction. Hard to imagine Ray. And when Ray tried to pay him back, he said, no, do the same with other people. So a really telling story. And his belief in Ray has been lavishly justified, lavishly warranted, lavishly rewarded in Ray's distinction as a career. He did his articles under Mrs. Victoria Nkenge, who became one of the victims of an apartheid atrocity when she and also her spouse were murdered. And Ray, I have a bit of long faribble, your Jewish audience will understand, in saying that she was murdered after some blood-curdling comments made by Nkosi Buthelezi. So I had to get that in, because I tried to cross-examine him on it in his defamation case, not very successfully. So Ray eventually opened his own firm, and it was at this point that he and I met. My recollection is that we met at a labor law conference in the 1980s, and it used to be when I was at my desk at the Center for Applied Legal Studies, just 20 or 30 meters away from here, that Ray would call me. He was younger than me, he was an emerging attorney, but also an emerging intellectual force. And what his official biographies do not record is the intensity and determination with which Ray grappled with every problem that he came across, both in his practice and in his academic writing. He was publishing in the Industrial Law Journal and also doing a wider range of practice. This impressed me, Ray's seriousness, because I was a sort of gunshot lawyer. I was always in search of a quick and effective answer to a difficult case. And Ray also wanted the answer, but he was determined to get to the conceptual heart of it in both the facts and the particular facts and the theories underlying it. It is these qualities that led John Myburgh, who was the first president of the Labour Court, to invite Ray to be a judge there. And almost at the same time, he invited another young 30-year-old in his 30s called Dunstan Mlambo to become a judge there too. So John Myburgh was a mentor to both a Deputy Chief Justice and a Chief Justice. Ray served on the Labour Court for 13 years, and after a short transition in the High Court, was appointed to the Constitutional Court, where I already was. It was the first Constitutional Court that had no Mandela appointees left. Let the record reflect, let it be said that our years as colleagues were not always easy. Ray, should I tell some stories?
I can tell some stories.
I won't. I promise you I won't. But let me quote to you. We differed. It's been written about in various articles and books about the differences in that court. But Ray, what I want to say is that the profundity of your commitment to constitutional principle, to constitutional truth, and to the judicial process were so profound that there was a confluence in our views and principles. I want to give one extract from a judgment of Ray. It was an early judgment that he wrote when there were two accused who'd been arrested in South Africa, and they were wanted for murder in Botswana, which still had and still applied the death penalty. And the question was whether we should release them for extradition to Botswana. And Ray wrote a magnificent judgment early in his career. We as a nation, he said, have chosen to walk the path of the advancement of human rights. By adopting the Constitution, we committed ourselves not to do certain things. One was that no matter who the person is and no matter what the crime is that he is alleged to have committed, we shall not in any way be party to his killing as a punishment, and we will not hand such person over to another country where to do so will expose him to the real risk of the execution of the death penalty. This path that we as a country have chosen for ourselves is not an easy one. Some of the consequences that may result from our choice are part of the price that we must be prepared to pay as a nation. I find that passage still, after 10 or 12 years, deeply moving, and I was privileged to be a concurring vote in Ray's judgment, an unanimous judgment of the court. Ray, in due course, succeeded Mogoeng as Chief Justice, and of course, his real turn in the spotlight and the severest pressure on him, I think much more than anything we did at the Constitutional Court, came when he was appointed to lead the Commission of Inquiry into allegations of state capture, corruption and fraud in the public sector, including organs of state, otherwise known as the Zondo Commission. I want to compare the Zondo Commission. It's been a time of reflection because of the Madlanga Commission and because of the parliamentary inquiry. But I want to compare what Ray did with the TRC. There was no opportunity for anyone in our country after respectively the TRC and Ray's commission to say we didn't know. The evidence before Ray was quite astonishing in its range and its depth, and in the scurrilous looting absence of protocols, absence of procedures that it revealed. And my impression, having sat with Ray for almost a decade before that, was that Ray's fundamental instincts, as a Zulu speaker, as a rural person, as someone who had battled his way into the most distinguished office in the judiciary, that he was profoundly offended by what he heard and saw in that commission. And while not all his recommendations, his lucid recommendations, have been implemented yet, the commission stands as a seedbed and a pathway to our future in this country. His recommendations, his findings, and the light that they represent, that they reflect on what we should be doing as a country, stand profoundly. And it's with that pride that I give the podium over to Chief Justice Ray Zondo. Thank you, Ray.
You know, Justice Cameron is a very tall man. To come to the podium after him when you are not so tall is not easy. Thank you very much, Edwin, for those very kind words that you have said about me. I probably would struggle to find words to describe you, both as a person and as a colleague. This man is an extraordinary human being. It's not the occasion to go into details, and he wouldn't like me to, but he is an extraordinary human being, and he was a wonderful colleague. And as he said, on law, we sometimes differed, but what characterized our differences all the time was the collegiality, because we were always aware that we were just differing on law or facts, but there was nothing personal. And we never had difficulty in interacting at personal level just because maybe there was this big case on which you couldn't differ. So he is an extraordinary human being. Maybe I should have started by saying good evening to everybody. Sanbonan, Dumelang. Thank you. It is a great honor and privilege for me to have been invited to deliver the 2025 Helen Suzman Memorial Lecture in memory of Helen Suzman, a fierce opponent of apartheid for many decades of her life, a strong fighter against forced removals, detentions without trial, and a great advocate for the rule of law and an independent judiciary. Indeed, a great human being. I therefore take this opportunity to thank the Helen Suzman Foundation for inviting me to deliver this year's memorial lecture this evening. I've been asked to deliver this year's lecture on the topic, and I quote, "Is there a need to re-examine the judicial appointment model in South Africa?" Given that Helen Suzman was a great Democrat and subscribed to the rule of law and an independent judiciary, the choice of the topic for this year's lecture is quite appropriate at this stage of our journey in this country. I say this in the light of the allegations that were made by Lieutenant General Nhlanhla Mkhwanazi on the 6th of July this year, where he said that there were people within the criminal justice system, including members of the judiciary, who were working with criminal syndicates effectively to defeat the ends of justice and to undermine the rule of law and our criminal justice system. An allegation that there are police officers, public prosecutors, and members of the judiciary who are working with criminal syndicates to defeat the ends of justice or to undermine our criminal justice system is one of the most serious allegations that anyone can make against the police, public prosecutors, magistrates, and judges. Because of the seriousness of such allegations, they should not be made lightly. But we are grateful that Lieutenant General Mkhwanazi blew the whistle so that the country could look into these allegations. And I'm happy that the President acted swiftly to establish the Madlanga Commission, from which we are already hearing shocking evidence. The allegations that Lieutenant General Mkhwanazi made in regard to certain members of the judiciary, public prosecutors, and the police relate to, in effect, the capture of certain persons in the criminal justice system. One way in which the judiciary may be captured is through the use of a country's judicial appointment system to bring into the judiciary people who have no integrity, who are not suitable for appointment as judges and magistrates, and who will be pliable and will compromise South Africa's justice system. It is in this context that I approach the topic of this evening's lecture, because this topic gives us an opportunity to scrutinize our judicial appointment model to see whether it is strong enough to withstand attempts by criminal syndicates and certain individuals, groups and families to capture the judiciary, or whether it has weaknesses that can be exploited by such elements in our society to capture members of the judiciary. A very important feature of our judicial appointment model is the Judicial Service Commission. This body is central to our judicial appointment system, as well as the system for the removal of judges from office. It was introduced into our law by the 1993 Interim Constitution. Its main function under that constitution, as is still the position under the final constitution today, is to facilitate the appointment of judges. I will talk more about the JSC shortly, but for now, let me talk about our model of judicial appointment. Our judicial appointment model begins with the advertisement by the JSC of a vacancy or vacancies in a court following upon the head of that court concerned informing the JSC of the existence of the vacancy or vacancies and asking that the vacancy or vacancies be advertised. The advertisement will call upon anybody who has somebody to nominate a suitable candidate or suitable candidates for vacancies that have been advertised. Individuals may make nominations, professional legal bodies and any other organizations may nominate candidates. The public is able to nominate candidates. After the expiry of the deadline for nominations, a sifting committee of the JSC, which has traditionally been chaired by the president of the SCA, meets to conduct the shortlisting process in respect of all the advertised vacancies. That committee identifies candidates who not only meet the minimum requirements for appointment, but also who have some prospect of appointment. The committee then compiles a list of shortlisted candidates who would be interviewed by the JSC in due course. That list is published in the media, and the public is given up to a certain date an opportunity to submit any comments that they may have in relation to each candidate. This gives members of the public an opportunity to send comments to the JSC about the suitability of the shortlisted candidates. After receiving comments, which include comments from the professional legal bodies and other organizations that take a special interest in the process of the appointment of judges, the JSC sends the comments to the candidates concerned so that the candidates may comment on any adverse comments about them that have been received from the public and from the legal bodies. Some of the bodies, such as the General Council of the Bar, send in very well-researched and comprehensive comments about each candidate, which is highly commendable. They read the judgments that have been handed down by the candidates and analyze them and provide comments on them. The comments are then shared with the candidates to enable them to respond to any adverse comments against them. Once the candidates have responded, the JSC has a committee that considers the objections and candidates' responses and takes a view as to which ones, namely comments, should be rejected and which ones need to be raised with the candidates or candidates concerned in the interviews. I pause here to point out that the opportunity to nominate candidates and the opportunity to object or comment on the candidates, which our judicial appointment model allows the public, is of vital importance to the legitimacy and credibility of the judges who will ultimately get appointed. This feature of our model does not need to be re-examined. It must remain. The next stage of our judicial appointment model, and I need to clarify that I focus on our model insofar as it relates to judges and do not include the one relating to magistrates, even though substantially it is also along the same lines. The next stage in terms of our judicial appointment model is the holding of interviews by the JSC to interview the shortlisted candidates. The interviews that are held by the JSC at this stage do not share the same purpose. This is because in terms of the Constitution, the JSC plays different roles in the judicial appointment process, depending on the category of the vacancies to be filled. Sometimes the purpose of the interviews is to enable the JSC to advise the president as to which candidate or candidates he should appoint to particular vacancies, in which case the president is obliged to appoint such candidate or candidates in accordance with the advice of the JSC. Sometimes the purpose of the JSC interviews is not to advise the president as to which candidate or candidates to appoint, but to act as a sifting mechanism to produce a certain list of suitable candidates from which the president may appoint, but ultimately has to appoint the candidates who will fill certain vacancies. Sometimes the purpose of a JSC interview is to enable the JSC to properly and effectively play a consultative role in terms of Section 174 of the Constitution before the president may make an appointment. I shall talk more about these three purposes of interviews of the JSC. Let me talk for now about the composition of the JSC. But before I do that, let me complete the process at the interviews. Once the interviews for a particular position has been completed, in other words, once all the candidates who are competing for a particular vacancy or vacancies have been interviewed, the JSC, in terms of our model of judicial appointment, will then meet in private. The interviews, as all of you I'm sure know, are held in public, and as I said earlier, they are normally televised, sometimes live. Then the JSC, after the interviews, will retreat and have its deliberations. And at the end of their deliberations, they will then vote. Now, the purposes of an interview or a JSC interview that I've talked about and that I've identified are important for members of the JSC to appreciate when they deliberate. Because if they don't appreciate the purpose for which a particular interview is conducted in terms of the Constitution, they may get things wrong. They may say they are making a recommendation to the president when they are supposed to advise the president. They may say they are advising the president when all they need to do is actually give the president a list of names of the most suitable of the candidates that they have interviewed and leave it to the president to decide which ones of those candidates he appoints. So I thought it's very important to mention that. I now wish to talk about the composition of the JSC. The composition of a body that plays such a critical role in the appointment of judges is very important, because if the composition is wrong, it's likely to affect the quality and sometimes the outcomes of their decisions and the contests for positions that they have to deal with. The Judicial Service Commission is established in terms of Section 1781 of the Constitution It is made up of the following role players: the Chief Justice, who chairs the Commission, the President of the Supreme Court of Appeal, a Judge President designated by the Judges President, the Minister of Justice, 2 practicing advocates nominated by the advocates profession to represent the advocates profession and appointed by the President, 2 practicing attorneys nominated by the attorneys profession to represent the attorneys profession and appointed by the President, 1 teacher of law designated by teachers of law at South African universities, 6 persons designated by the National Assembly, from among its members, at least 3 of whom must be members of opposition parties represented in the National Assembly, 4 permanent delegates to the National Council of Provinces, designated together by the Council with a supporting vote of at least 6 provinces. 4 persons designated by the President as head of the National Executive after consulting with the leaders of all parties in the National Assembly. And when considering matters relating to a specific division of the High Court, the Judge President of that division and the Premier of the province concerned, or an alternate designated by each of them. The composition of the JSC, which is in the final constitution, remains the same composition of the JSC as the JSC was constituted under Section 105 of the 1993 Constitution, except that under the 1993 Constitution, there was a provision for 4 senators to be included, who have, in the final constitution, been replaced by the 4 permanent delegates to whom I referred a minute ago. But also, the final constitution has added another provision, namely a provision for the inclusion of 6 members of the National Assembly in the JSC. In other words, under the 1993 Constitution, you had no members of the National Assembly who were part of the JSC. You just had 4 senators who came from the Senate. I hope we can all remember that once upon a time we had a Senate. Those are the people that you had which came from Parliament. But under the final Constitution, there was an addition of members of the National Assembly. The addition of 6 members of the National Assembly to the JSC in the final Constitution expanded the JSC from a body that was made up of 17 members when sitting to deal with matters that did not relate to a division of the High Court to 19. And from 19, when it dealt with matters relating to a division of the High Court, to 25 members. So now, the current JSC, when it sits to deal with matters that relate to, a division of the High Court, or a specialist court that enjoys the same level as the High Court, it sits as 23, but, it sits as 25 if it deals with a matter relating to a division of the High Court. Also, if it is dealing with matters that relate to specialist courts. But when it is dealing with a matter that doesn't relate to a division of the High Court, but relates to the other superior courts, the SCA, Supreme Court of Appeal, and the Constitutional Court, namely those are courts of national status and not provincial, then it sits as 23, that is the JSC. So depending on what the matter is before it, it will expand or contract. In the light of the composition of the JSC, both under the 1993 interim constitution and under the final constitution, it is fair to say that for all intents and purposes, except for the new 6 members of the National Assembly, the JSC, as we have it today, is still substantially composed the way it was about 31 years ago. One little difference also is that under the 1993 Constitution, 2 of the 4 members that the president had power to appoint or designate to the JSC needed to be attorneys or advocates. Under the final constitution, there are 4 persons that the president is given power to designate, but there's no provision that they need to be lawyers, which means it can be lay people in that sense. The stakeholders or interest groups who are represented in the JSC are the following: the judiciary, the executive, the advocates profession, the attorneys profession, faculties of law, the National Assembly, the National Council of Provinces, the public, and the relevant provincial executives where a division of a high court is involved, is being dealt with. Except for the addition of the members of the National Assembly, the stakeholders or interest groups that were represented in the JSC under the 1993 interim constitution are still the same stakeholders represented in the JSC today. I do not make this point to complain that there is a stakeholder or interest group that should have also been accommodated in the composition of the JSC, but that is not accommodated. I make the point to highlight the fact that the composition of the JSC, as it was 31 years ago, was very inclusive, which is commendable, because even after 3 decades since the JSC was established, the stakeholders it accommodated are still the same stakeholders that it accommodates now. I mentioned earlier the issue of the purposes of the interviews that are held by the JSC. And I go back to that topic or that issue to talk more about it, now that we have a good idea of the composition of the JSC and the interest groups and the stakeholders who are represented in the JSC. When the JSC interviews candidates for appointment as judges or for the promotion of judges from one level to another level in the same court or from one court to another, it does so for one of 3 purposes. One is for the JSC to advise the president, which I've already mentioned. Another is for the JSC to express its views on the suitability of candidates for the leadership positions in the SA and the Constitutional Court. And the last one is for the JSC to sift candidates and produce a list as required by Section 174(4) of the Constitution. That is the list of the most suitable of the candidates that is given to the president, from which the president will choose the candidates for the Constitutional Court. When does the JSC conduct interviews for the purpose of advising the president as to which candidate or candidates to appoint as a judge or judges, or as to which judges to promote? The interviews that are conducted by the JSC for this purpose are those that relate to the appointment of judges of the High Court and the specialist courts, including the appointment of judges president, deputy judges president, and in the various divisions of the High Court and in the specialist courts. The constitutional basis for the JSC to advise the president as to which candidate or candidates to appoint in respect of these courts is Section 174(4) 1746 of the Constitution. That provision reads, and I quote, "The President must appoint the judges of all other courts on the advice of the Judicial Service Commission," close quotes. Before Section 1746, Section 174 has dealt with the appointment by the President of the Chief Justice and Deputy Chief Justice, as well as the President and Deputy President of the Supreme Court of Appeal. All of those are dealt with in Section 1743 of the Constitution. Then in Section 1744, the Constitution then deals with the appointment of the justices of the Constitutional Court other than the Chief Justice and the Deputy Chief Justice. And then after that, in Section 1746, then it deals with the appointment of all other judges of other courts other than those that have been specifically dealt with already in that section. That is why the section says the President must appoint the judges of all other courts on the advice of the Judicial Service Commission. Section 1746 means that the JSC needs to advise the President before he or she can appoint a candidate as a judge of any division of the High Court or any specialist court, enjoying the same status as the High Court, including the Judge President or Deputy Judge President, as well as a Judge of Appeal in the Supreme Court of Appeal. They also fall under Section 1746 of the Constitution. Section 1746 also means that once the President has received the JSC's advice, he or she is obliged to appoint in accordance with that advice. He or she cannot do otherwise. In this regard, it must be noted that Section 1746 says must appoint. And it says, and it doesn't say may appoint. And it says on the advice of the Judicial Service Commission. This phrase, on the advice of the Judicial Service Commission, comes from the interim constitution, but it was not put as on the advice of the Judicial Service Commission in that constitution. In that constitution, the Constitution said the President shall appoint a candidate in accordance with the advice of the Judicial Service Commission. So the idea is the same, but the wording has been reformulated. But it's important to underline the importance of the word must in that provision. The President must appoint on the advice of the JSC. Section 104, subsection 1 of the 1993 Interim Constitution read as follows, just to underline what I've just said, and I quote, "Judges of the Supreme Court," and at that time we didn't call the High Court, we called it the Supreme Court, and it had provincial divisions and the appellate division. "Judges of the Supreme Court shall be fit and proper persons appointed by the President, acting on the advice of the Judicial Service Commission, provided that the appointment of acting judges shall be as may be provided for in an act of Parliament." So that's where the phrase comes from. In respect of the appointment of the President and Deputy President of the Supreme Court of Appeal, the JSC is only entitled to being consulted by the President. maybe before I say that, I need to mention that when you look at the scheme of Section 174, you will see that this section is quite carefully crafted, because you will find that in regard to certain appointments or certain positions, the JSC is consulted, like Chief Justice, Deputy Chief Justice, President of the SA, and Deputy President. But when it comes to the appointment of justices of the Constitutional Court, the JSC has no right to be consulted by the President. It's only the Chief Justice who is entitled to be consulted by the President. The role of the JSC is sifting the candidates to produce the list that it will send to the President. But nevertheless, the power that it has, namely the JSC, in being the body that must give the President the list, is a very strong power, because the President is confined to that list when he appoints or she appoints. He can't go outside that list. Section 1744 allows the President, if there is a candidate that he or she is unhappy, that she finds unacceptable in that list, to go back to the JSC and state his position, but the Constitution requires him to give reasons why that candidate is unacceptable, which is quite important, one, for transparency, two, for accountability, so that he can't just say, I don't like this one, I don't want this one. He's obliged to come up with reasons that are going to be known why he's not happy with a particular candidate that the JSC thought was fine. And then the JSC looks at his reasons, and then the Constitution says the JSC must then supplement that list. And once it has supplemented that list, the President can't ask the JSC for another list. At that stage, the Constitution says he must appoint. So in a way, that becomes a deadlock-breaking mechanism, so that you stop the toing and froing between the JSC and the President that could otherwise happen when they can't agree. So, I thought that I would emphasize that as well. But in respect of the appointment of the President and Deputy President of the Supreme Court of Appeal, the JSC is only limited to being consulted by the President. The JSC plays the same role in respect of the appointment of the Chief Justice and Deputy Chief Justice. And in terms of Section 1743, the President appoints all these four judges after consulting the JSC. However, in respect of the Chief Justice and Deputy Chief Justice, he is additionally required to appoint after consulting leaders of political parties represented in the National Assembly. So in respect of these four positions, Chief Justice, Deputy Chief Justice, President of the SCA, and Deputy President of the SCA, the JSC's function is to play its part in the consultation process and to express its views about the suitability of those candidates. At the time of the interim constitution, the head of the Constitutional Court was styled as the President of the Constitutional Court, but is now the Chief Justice. At the time of the interim constitution, the head of the Supreme Court of Appeal was styled as Chief Justice, but is now the President of the SCA. In terms of Section 972 of the interim constitution, the President of the Constitutional Court, who is now the Chief Justice of South Africa, and the head of the Constitutional Court had to be appointed by the President in consultation with the Cabinet, and after consultation with the Chief Justice, who is now the President of the Supreme Court of Appeal. The head of the Supreme Court of Appeal then was called Chief Justice. In terms of Section 99.996, read with Section 99.5 of the interim constitution, the JSC had no role to play in the appointment of the first president of the Constitutional Court. Now, I say just a little bit more with regard to the functions of the JSC. In terms of Section 97(1) of the Interim Constitution, the head of the Appellate Division of the Supreme Court, who was the Chief Justice, as I have said, was appointed by the President in consultation with the Cabinet and after consultation with the Judicial Service Commission. In terms of Section 97(2) of the Interim Constitution, the head of the Constitutional Court was appointed in consultation with the Cabinet and after consultation with the President, with Chief Justice. What is clear from Section 97(1) and 2 of the Interim Constitution is that the appointment of both the head of the court, now known as the Supreme Court of Appeal, and the head of the Constitutional Court by the President had both to be in consultation with the Cabinet. But that requirement was not carried over into the final Constitution. Additionally, it is also clear from those provisions, namely Section 97(1) and 2, that the further consultation that was required was not the same as the one that involved the Cabinet. In respect of the head of the Appellate Division, the further consultation that the President had to undertake, which was with the JSC, was not the same as the one he had to have with the Cabinet. As far as the JSC was concerned, the President was simply required to appoint the head of the Appellate Division after consultation with the JSC. Also, with reference to the appointment of the head of the Constitutional Court, the President had to appoint him or her after consultation with the Chief Justice. It is noteworthy that for the appointment of the head of the Appellate Division of the Supreme Court, the President needed to consult with the JSC, apart from appointing such head in consultation with the Cabinet. Whereas with regard to the appointment of the head of the Constitutional Court, the President did not have to consult the JSC, but had to consult the head of the Appellate Division of the Supreme Court. I mention this so that we can see what changes there have been that we find in the final Constitution that were there in the interim Constitution in order for us to appreciate certain features of our model of judicial appointment. The fact that Section 97 of the Interim Constitution used both the phrase in consultation and after consultation to describe the President's obligations in the appointment of the head of the court, now known as the Supreme Court of Appeal, and the head of the Constitutional Court makes it clear that the drafters of the Interim Constitution were clear that were clear about the distinction between the two expressions, the one needing the concurrence of the other party and the other not needing such concurrence. In Section 174(3) of the final Constitution, the phrase in consultation with the Cabinet was not included, but the phrase after consulting was retained. Under Section 174(3), the heads of these two courts, after consulting the JSC, the heads of these two courts were appointed by the President after consulting the JSC, but in respect of the head of the Constitutional Court, also after consulting leaders of all political parties represented in Parliament. I've already dealt with the issue of the appointment of justices of the Constitutional Court and the fact that the JSC is not being consulted or does not get consulted by the President in regard to their appointment, but only gets consulted in regard to the Chief Justice, Deputy Chief Justice, President of the SCA and Deputy President of the SCA, who the person who gets consulted by the President in regard to the justices of the Constitutional Court is the Chief Justice. I do not think that the fact that the requirement of the Cabinet's concurrence on the appointment of the head of the two courts was not carried forward into the final constitution has in reality weakened the position in any way, because the cabinet was always going to agree with the president's choice. I think the interim constitution and the final constitution enjoyed virtually the same strength or weakness depending on how one sees it. The consultation required by Section 174 does not require the concurrence of the JSC. That consultation simply entails the JSC expressing its views about whether the candidates considered for the positions contained or referred to in Section 1743 is or are suitable for the positions for which they are nominated. Section 1743 does not make any reference to the JSC making any recommendations to the President with regard to the appointment of a Chief Justice, Deputy Chief Justice, or President or Deputy President of the Supreme Court of Appeal. It does not appear that the JSC has got power to make recommendations to the President under Section 174. This can be said for three reasons. The first is that Section 1743 makes no reference to a recommendation. The second is that in the 1993 constitutional regime for the appointment of judges, that constitution had provisions where there was a requirement that the appointment of certain judges be made by the President acting on the recommendations of the JSC. In this regard, reference can be made to Section 105, 2A and B of the interim constitution. Section 105, 2A and B provided for the functions of the JSC as including, and I quote, A, to make recommendations regarding the appointment, removal from office, term of office, and tenure of judges of the Supreme Court in terms of Section 104. B, to make recommendations regarding the removal from office of judges if the Constitutional Court in terms of Section 104.4. Also, Section 995 of the interim constitution read, and I quote, subject to subsection 6, an appointments under Section 97.2 or subsection 4 or 7 of this section shall only be made from the recommendations of the Judicial Service Commission. The point I am making is that under the 1993 constitution regime for the appointment of certain judges, that constitution required the appointment of certain judges to be made on the recommendation of the JSC. The drafters of the final constitution were obviously aware of those provisions of the interim constitution. The fact that they did not include those provisions or any provisions to the same effect about the JSC making a recommendation to the President in regard to the appointment of any judges can only mean that the purpose thereof was deliberately not to give the JSC any power, whether under Section 1743 or 1744 or 1746, to make recommendations to the President. The JSC makes or provides advice to the President under certain circumstances, gets consulted under certain circumstances, and provides a sifting process in order to produce a list under other circumstances to make sure that the President has got enough suitable candidates from which he or she can make the appointment. When one then looks at the composition of the JSC, and one looks at the functions of the JSC, and I've dealt with both the composition and the functions. One, we can see that as far as public participation, there is good public participation in our model. Two, we can see that the powers or the roles to be played by the President and the Deputy President and the President, the JSC and the President, are very clearly defined. Under certain circumstances, for all intents and purposes, the appointing authority is the JSC, even though the president, as a matter of formality, must sign the appointment. That is under section 1746, the appointment of high court judges, judges president of the high courts and specialist courts, and the appointment of judges of appeal in the Supreme Court of Appeal, except for the president and deputy president of that court. There, the role of the JSC is to advise, and the president doesn't have much room to appoint somebody other than the person advised by the JSC. When it comes to the Constitutional Court, as far as justices of the Constitutional Court are concerned, the president has got a lot of power as to who he appoints. But the JSC doesn't have the right to be consulted. Only the Chief Justice has that power. But the power of the JSC is in the fact that it is the only body that can come up with a list to send to the president and say, these are the people from whom you can choose. So in the end, that's a very strong power. But in terms of which individual, it's up to the president. And then I've already talked about consultation. So when one looks at the composition and the functions, then one needs to come back and say, and I've said that the composition of the JSC covers all important stakeholders. The next issue is the question of the level of representation of the different stakeholders. I'm not going to talk about all of them. I'll mention a few. The judiciary is a very important stakeholder because these are appointments that relate to the judiciary. But when you look at section 178 of the Constitution, where you find the composition of the JSC, you'll find that when the JSC sits to deal with matters relating to judges of appeal in the Supreme Court of Appeal, President and Deputy President of the Supreme Court of Appeal, judges of the Constitutional Court and Chief Justice and Deputy Chief Justice, you have a body of 23, but there are only 3 judges representing the judiciary. It's the Chief Justice, it's the President of the SCA, it's the Judge President who has been designated by the other judges president. It seems to me that that's completely inadequate representation for the judiciary. In a body of 23, that is about judges, but you only have 3 judges there. But then you look at the number of, the level of representation of parliament. You have 6 members of the National Assembly in terms of section 178 that must be part of the JSC. And you have 4 members from the NCOP who must be part of the JSC. So the legislature is represented by 10 members in a body that deals with the appointment of judges. And then the president is given power by section 178 to designate 4 other persons. Now, excuse me, those other persons are not required not to be politicians. So they can be politicians. You see, in the interim constitution, those 4 persons, the constitution said 2 of them must be lawyers. This one, final constitution simply says 4 persons. And the only other requirement is that that is the president, consult leaders of political parties in the National Assembly. So again, the role of politicians in this body. So you have 10 against 3. So that's one level. Another level is this, that when the JSC sits to deal with the appointment of judges of the Supreme Court of Appeal and judges of the Constitutional Court, it sits as 23. Now the majority that is required, because the JSC must take its decisions by majority. If it sits as 23, it must have 12 members who vote for a certain decision. Okay? I've already told you that just the 6 members from the National Assembly and the 4 members from the National Assembly, from the NCOP, that's 10 already, 10 politicians. So just need 2 more, then politicians decide a very important issue, a very important appointment. But it gets worse than that. Because I must just point this out, the 6 members from the National Assembly, 3 of them at least must be members of opposition parties. So that's helpful up to some point. But they are still politicians. Then the Constitution gives the president power to designate 4 other persons, and without any qualification as to what type of people those should be. Therefore, a president would be entitled to designate members from his or her party. So I'm saying a president, whichever president who might wish to ensure that the JSC has got people, as many people as possible who would have a certain approach to issues, maybe to the appointment of judges, can say, and this would apply if there is a majority party in parliament. At the moment there isn't. But if there is a majority party, the 3 members of the National Assembly would come from the majority party, the other 3 from the opposition parties. And then there would be 4 members from the NCOP. Now, those 4 members from the NCOP can easily can easily come from the majority party if the majority party enjoys support in 6 or more provinces, because that's what the Constitution is. Those who come from the NCOP must enjoy the support of at least 6 provinces. So if you have got a majority party that enjoys support in 6 or more provinces, they can easily come from the majority party. And then when the president appoints the 4 persons that he's given power to appoint, wide power, that president could then appoint members of his or her party. That would then mean 3 from the National Assembly belong to the majority party, 4 from the NCOP could belong to the majority party, that makes it 7, and then 4 that the president appoints, that would take us from 7 to 11. Is that correct? And then you add the Minister of Justice, then it's 12. Then they've got majority. So if at any stage we were to have a president who is either captured by whatever interest groups, including criminal syndicates of certain families, and they want to undermine the rule of law, and they want to achieve certain appointments for their own purposes, it is possible for such a president, working together with his or her majority party to actually achieve a JSC composition that has got 12 members from the majority party. And that 12 can decide anything that the JSC has to decide when they sit as 23. It's the appointments in the Constitutional Court, it's the appointment in the Supreme Court of Appeal, except that I have to mention that I did say how the powers of the JSC are strong in certain circumstances and not strong in other circumstances in the appointment of different categories in those courts. But they would have that power. And then the president, of course, would be belonging to the same party. So for me, there lies a very big danger in our model of judicial appointment. One is the low level of judicial representation, and two is the fact that it is possible for the president, for a president who has a majority party in parliament and maybe in the provinces, to actually dominate and get whatever he or she wants through the JSC. Now, this becomes quite important when we have allegations such as the ones that General Mkhwanazi has made about criminal syndicates that seek to capture the criminal justice system. I believe that while we have a situation where there is no majority party in parliament, this is the best time for us as South Africans to look at what may need to be done to fix Section 174 of or Section 178 of the Constitution with regard to the composition. It's not clear to me why the president needs to be given power to appoint 4 persons altogether, in addition to the fact that members of the majority party, if he has majority party in parliament, are already there. But certainly, the level of representation for the judiciary is woefully low. And if we want to take steps to try and minimize the chances that in the future, a president who is captured by criminal syndicates or by whatever families who might want to use to capture the judiciary, if we want to avoid that or to minimize those prospects, we should raise the representation of the judiciary in the JSC, and we should make sure that we don't have a situation such as this one, which can happen. If we fail to act to deal with this, we may live to regret one day. Thank you very much. Welcome here, welcome there.
Thank you very much, former Chief Justice. You can have a seat. You've been on your feet for a bit. We now have an opportunity for you to raise comments and questions with former Chief Justice Zondo on what was an excellent delivery and some very thought-provoking stuff at the end. So Chanel and Lorette are going to walk around with some mics, and we'll take a series of questions. Thank you. Any hands?
I apologize in case my talk was technical.
Okay. Good morning, Honorable. Good evening, sorry. Good evening, Honorable Chief Justice Zondo. Good evening, everyone. My name is Noluthando. Noluthando is coming from the Revelation Spiritual Institution Home, Temple, and from the Mzuvuglis Lapat Biza Khatebe Institute. As I've just said, mine is not a question, it's a concern. I don't undermine what is said in the room, but what I'm saying, I would like to propose for the inclusion of ancient customary laws underpinned by spiritual foundations from our institute. The reason for this is that ancient customary laws are not the same as common law or English law. I suppose the justice system or the justice institutions are using the common law and English law. Please correct me if I'm wrong. To move forward, because I've got, I think, a long presentation.
Unfortunately, we
But-
won't have time. I think you have made your point. Thank you very much. I'll take two more and then have Chief Justice respond. Can go there, Ezekiel, and then this side.
Chief Justice, good evening. I trust that you're well. In the past, you've made reference to the fact that the foremost obligation to an exceptional legal practitioner is to advise the client and persuade the judge. Amongst the role of legal practitioners, what would you say is the foremost obligation of a judge, other than that of remaining steadfast towards constitutional principles?
Thank you. We'll take one more.
I'm sorry, I have nothing to make notes
Notes
on.
on,
I'm going
okay.
to forget. But maybe while you are going to, the mic is going to somebody else, if you could just repeat that question, I would just want to make sure I understood.
The initial speaker spoke about how you've made partial recommendations about the potential criterion with which judges at the JSC can be selected upon or focused on. What is the foremost criteria that you expect the JSC to pay particular attention to? If I could draw your attention last year to the catastrophe of the Western Cape High Court Division.
The gentleman here.
Yes. Good evening, Justice Zondo. My name is Debo Kas from Public Interest SA. Yes, it was technical, but we followed as non-lawyers, and it really made sense in the end. My question is, much as we could and we should focus on the appointments of the judiciary per se, the judiciary is a subset of the criminal justice system, which comprises, I would argue, three other elements. That is the policing and the prosecution. The judiciary is as strong as the weakest link in the criminal justice system, because you have to adjudicate based on what has been investigated, the A1 statements that we are laying before you, and how the arguments are delivered by the prosecution. Now, if we focus a lot more on how the appointments of the judiciary is concerned, I think we should also, with the same breath, focus on how the head of the police system and the head of the NPA is concerned. And I'm saying this because very soon there will be appointments or interviews for appointments of the National Director of Public Prosecution. And we don't see anyway a strong presence of lawyers in those nominated, I think, by the president to actually serve in that. Shouldn't this be an opportunity to actually use the same approach as it is with appointment of judges in such? Similarly, next year, unless something happens, we'll still have to appoint a new police commissioner. And again, we're at the mercy of the president. Just your thoughts around that. Thank you.
Thank you. Over to you.
Shall I come
Yeah, sure.
The first was a comment, so I'm not going to say much. Safe to say that obviously, when you talk about a composition, the composition of any body or entity, you need to draw a line somewhere, because there would be so many interest groups that actually would want to be part of it. So you have got to draw a line somewhere between making the body too big and not making it too small. As to which entities you allow in and which ones you don't allow in can be quite a difficult exercise. So that's all I can mention. As I was preparing this talk, I thought about the fact that in the JSC we don't have the police, and the police could say, we are in the criminal justice system, why are we not represented in the JSC? So that's all I can mention, that somewhere a line would need to be drawn, but exactly where it should be drawn would be a matter for debate. The second speaker, the foremost criterion for the appointment of judges is, to me, very clear. Above all criteria is the integrity of the candidates, is the integrity of the people who want to be judges or who are considered to be judges. I don't care how much law you can know, how scholarly you can be. If you don't have integrity, you don't belong to the judiciary. For me, that's the most fundamental criterion. And if I was given two people and I was told they are going to be, one of them is going to be a judge in my case and I must choose which one, and I was told that the one knows law a lot but has no integrity, the other one has integrity but doesn't know law much, I'll go for the latter, the one who has integrity. That's the one I would rather go with, rather than the one who knows the law a lot but has no integrity. The third speaker talked about us not neglecting the situation among the other stakeholders in the criminal justice system, the police and the prosecutors. I agree. The only reason why I was focusing on the judiciary is because of the topic. But otherwise, we need similar measures for the prosecutors and for the police. Actually, those of you who may have had a chance to read, I know that not many people have read the whole report of the commission that I chaired, but well, I met one in Cape Town, a professor who said she read it, the whole of it, for the research and book that she wanted to write. But there is a volume where we made recommendations with regard to the appointment of members of boards of SOEs. And one of the questions, you will be aware that a lot of state capture corruption happened in SOEs. And the commission had to answer the question, what went wrong? Why was it that this is what happened in the SOEs? And it was quite clear, particularly in regard to ESCOP. The evidence was very clear of, for example, Mr. Salim Essa sending names to the chairperson of of ESCOM at the time, Mr. Tsotsi, in January, from December 2010 and early months of 2011, when the new board was considering committees of the board who would serve in the committees. Salim Essa was sending names to Mr. Tsotsi and saying to him, send these names to the minister as your suggestions, your recommendations of who should be in what committee of the board. So in regard to dealing with that, we made recommendations where we were, in a way, seeking to come as close as possible to how the JSC, for example, deals with the appointments of High Court judges, the Section 1746 situation that I talked about, where the JSC advises the president and the president is obliged to appoint the person that he has been advised to appoint. We wanted to come as close as possible to that scenario in order to try and strengthen that. But you are right. How do provincial commissioners of the police get appointed? How does the National Commissioner of Police get appointed? Those people need to have absolute integrity. They need to be appointed, and their terms should be such that they should not feel that they have to be nice to politicians, because the politicians are the ones who may have to renew their contracts. It shouldn't be people who are going to be subjected to that. It should be once you, certainly with the national commissioner, but the provincial commissioner, same thing is going to happen if the renewal of their contract is going to depend on politicians. You might struggle to find somebody, when faced with a lot of pressure, who is going to say, come what may, I'm going to make sure that this particular figure who needs to be arrested is going to be arrested. So we need to do something about those things, I agree. Thank you.
Last round. Take the gentleman there on the right, and behind you, and then at the back.
Judge Zondo, you apologize for giving a technical address. If I can ask a technical question. This relates to the three appointees from the National Assembly. Sometimes you refer to them as being from the opposition, and sometimes you refer to them being from minority parties. In our present structure, what would constitute a minority party? Would those parties that are in a minority but are in the government of national unity be included in the other three, or would they be part of the three that are of government?
My short answer is I'm not sure. But it is quite clear that the purpose of the drafters of the Constitution was to avoid a situation where all the six could come from the same party. That is why the provision says at least three of whom should come from the opposition parties. I would think that if you are part of the national government, you are not an opposition party. Who are you opposing? So I can't say that my answer is correct, but I would think that if you are in part of the executive, you are not an opposition party. But there might be some more learned on these things who might be able to say, no, that's wrong. Thank you.
Evening, Judge President. In 2025, I'd like to ask, do you think the South African Constitution is one of the best in the world? The reason I ask that is, if it is, according to you, why is it that our country is facing the most problems? If you can analyze and see it, the highest unemployment, highest Gini coefficient, most unequal country in the world, landless majority. Thank you.
I'm going to make sure that I hand over the mic after this so that she controls where we stop. One, I can't say that our constitution is the best in the world because I've never undertaken the exercise of comparing the constitutions of the world to see if it's the best. But I do understand that it's one of the most progressive constitutions you can find in the world. So that said, your next question is, if it's such a good constitution, why are we having all of these problems that you mentioned? My answer to you is that we must remember that the Constitution, although very important, is a document. It is not a human being. It doesn't have hands to do things that are supposed to be done. It doesn't make decisions that are supposed to be made. Sometimes I do hear people in the public discourse blaming the Constitution for a lot of things that are not right in our country. In many instances, my observation is that it's not the Constitution. The problem is that people who have been appointed or elected to certain positions, who took the oath prescribed by the Constitution, effectively to put the people of South Africa first. A lot of those people have failed to put the people of South Africa first. A lot of those people have failed to carry out constitutional obligations to improve the lives of people. And they want to blame the Constitution instead of accepting responsibility for their failures. I'm not saying that it's everybody, but a lot of them, I observe, have had opportunities to ensure that in accordance with what is envisaged in the Constitution, we are a better country. And they have failed, and sometimes some of them are at the forefront of making sure that we don't go forward. Thank you.
I think that's an excellent note to end today's discussion. But before we do, I would like to hand over to our chairperson for his closing address. Thank you very much, Khalim.
Chief Justice, in that last answer that you gave about the abrogation of those who hold public power, I was heartened by the words that you used, integrity, because to me, that seems to be the distillation of the essence of what is required in public life. Chief Justice, thank you very much for tonight. I found tonight fascinating because it covered two things. You called it technical. I will call it a forensic masterclass on the history, the context, the evolution of the judicial appointment process, but it was also a cautionary about the dangers and the vulnerability of this process to future state capture or future capture. You mentioned several things for us to think about. You mentioned, of course, the composition of the JSC and the level of judicial participation. You also mentioned the private retreat of deliberations. And that's something, actually, that the Helen Suzman Foundation has historically made submissions on in terms of the potential for making such deliberations public while finding a balance for commissioners to be able to deliberate freely. I'd like to end off this vote of thanks by actually ending off where we began tonight. Justice Cameron started off by talking about the young Mr. Zondo in Limpopo and Mr. Bucks, which is such a wonderful story. When I think, though, of Limpopo, I think of Alan Payton, himself a great friend and supporter of Helen Suzman. There is a lovely road that runs from Limpopo into the hills. These hills are grass-covered and rolling, and they are lovely beyond any singing of it. The grass is rich and matted, and you cannot see the soil. It holds the rain and the mist, and they seep into the ground, feeding the streams in every kloof. Stand unshod upon it, for the ground is holy, being even as it comes from the Creator. Keep it, guard it, care for it keeps men, guards men, cares for men. Chief Justice, you have reminded us tonight that if we are, as a nation, still in pursuit of our unfulfilled promise, that we need a courageous, independent, integrity-filled judiciary. It is one of the areas of holy ground, I think, as Alan Payton might put it. And you've shown us that at this time, this particular time of our democracy, that we should be thinking about how to safeguard it, to safeguard its powers and keep it holy. Around so much of the world today, actually, not just in South Africa, the pillars of the judiciary are facing real threats and are vulnerable. And so your calls for us to think about this particular time, which might be opportune for us, is a time where I hope it's not squandered. Certainly from the Helen Suzman Foundation's perspective, we would like now, after your speech, to think about how we, in our own small way, can make practical contributions and practical proposals around some of the issues that you have raised tonight. Ladies and gentlemen, on behalf of my Executive Director, Nasima, and my fellow trustees, I would like to thank the Chief Justice for addressing us tonight, along with the esteemed Justice Cameron. Both of you are supporters of our foundation, and it means a lot that both of you were here tonight. It has been a fascinating evening, and thank you all for coming. Good night.